Hi everyone, it's lecture 2. Can I check please that you can hear me and you can see me? I need to check because I can't see any of you and I can only hear myself. Brilliant, thank you very much indeed. Welcome back. Now, we're looking at the transfer of property and risk rules. We need to know when the buyer becomes the owner, because whoever has property in the goods, in other words, whoever is the owner, has the risk in them. But even before we can look into when property is transferred to a buyer, we looked at risk and frustration because it affects the contract itself. With specific goods, we discussed section 6 and section 7. Section 6 says, where there is a contract for the sale of specific goods and the goods without the knowledge of the seller have perished at the time the contract is made, the contract is void. Essentially, this is the same as common law mistake. Section 7 says, where there's an agreement to sell specific goods and then, without anyone's fault, the goods perish before risk passes to the buyer, the agreement is avoided. Now, if the contract is avoided, it means the seller does not have to deliver and the buyer does not have to pay. Essentially, this is the same as frustration. No one's fault. The contract has become impossible to perform. What happens if unascertained goods perish? Well, sections 6 and 7 do not apply. With unascertained goods, it depends on the type of unascertained goods we're looking at. There are two types, remember. The generic unascertained goods, example, I sell you 100 tons of wheat. It's very difficult to frustrate such contracts. The second type of unascertained goods is the specified quantity of unascertained goods out of an identified bulk. Example, I sell you 200 tons of wheat out of the 1,000 tons currently in my warehouse. Now, if my warehouse blows up and all the goods are destroyed, then the contract is frustrated at common law, and the remedies are under the 1943 Act. If my warehouse blows up, but only part of the goods are destroyed, we will see a little bit later on today the case of Stearns against Vickers. What we're trying to work out is when someone becomes the owner of goods, because whoever is the owner has the risk in the goods. That's what section 20 sub 1 of the Sale of Goods Act says. Remember, we only ever look at passing of property rules if goods are damaged or destroyed and the parties did not agree anything about risk. So when the contract parties did not agree anything about risk, when does property pass? Well, with specific goods, the starting point is section 17. Section 17 says property passes when the parties so intend. How do we work out what the parties' intentions are? Well, we look at three things. First of all, contract terms. If the contract does not say anything, then look at the second thing, the circumstances of the case. If the intention of the parties is still not clear, then the third thing to do is to look at the section 18 rules. That's the situation with specific goods. What about unascertained goods? When does property pass? Well, section 16 is the starting point. Section 16 says property in unascertained goods does not pass to the buyer unless and until the goods have been ascertained. So how do goods become ascertained? Well, there must be some outward sign of identification. Goods can also be ascertained by exhaustion. Now, there is one very important exception under section 20 big A, which deals with the second type of unascertained goods. In other words, specified quantity of unascertained goods out of an identified bulk. We will discuss this later. Now, when goods are specific or when goods have become ascertained, we said property passes when the parties so intend. Section 17 says that. If the intention is not clear, then look at the rules in section 18. There are 5 rules under section 18. The first 4 deal with specific goods. 18 Rule 1 says, where there is an unconditional contract for the sale of specific goods in a deliverable state, property passes when the contract is made. It is immaterial that time of payment or delivery is postponed. The big difference between section 18 Rule 1 and 18 Rule 2 is that in 18 Rule 2, the goods are not yet in a deliverable state. Section 18 Rule 2 says, if specific goods are not yet in a deliverable state because the seller still has something to do to it, in other words, to pack the goods, property only passes when that thing is done and the buyer has notice of it. Notice means actual notice. So property will not pass to the buyer until the seller has done what he agreed to do to the goods to get them into a deliverable state. And the buyer has notice that the work has been done. That's where we got to yesterday. Now, let's move on. Section 18, Rule 3 is very straightforward. Rule 3 says, if specific goods are in a deliverable state, but the seller must weigh or test it to ascertain price, property will not pass until the act is done and the buyer has notice of it. Very straightforward. Section 18, Rule 4 deals with goods which have been delivered on approval or on a sale or return basis. Well, technically, actually, in a sale or return, there is no contract. There is no agreement to sell. The seller merely offers to sell. So unless the buyer accepts, there is no contract. That's pure offer and acceptance. So the notice of rejection, which we'll be discussing, is actually just notice that the offeree rejects the seller's offer. So technically, Rule 4 doesn't involve a seller or a buyer, just an offeror and offeree. Be that as it may, Section 18, Rule 4 says, property passes in 2 ways. First, when the buyer signifies approval or acceptance to the seller. Example, let's say a shop lets me take some jewelry on a sale or return basis. I telephone the shop to say, wow, fantastic, I love it. Now, when I do this, I am signifying my acceptance of the jewelry, and property passes to me under Rule 4. Property also passes to the buyer if the buyer does an act adopting the transaction. The case authority is Kirkham against Attenborough. The owner delivered jewelry to a potential buyer on a sale or return basis. The buyer pledged the jewelry with a pawnbroker who took the goods in good faith. The owner brought an action against the pawnbroker. The action failed. Although the buyer had no title to goods, his act of pledging constituted adoption of the contract, at which point title passed to him. If the buyer had title, then of course the buyer can pass good title to the pawnbroker. Note again, please, that we only look at the Section 18 rules if the parties do not themselves agree otherwise. See, if the owner had expressly said to the potential buyer that title will not pass until the owner has been expressly told of the buyer's acceptance of the contract, the pawnbroker would not have got good title from the buyer, and the jeweler could then have recovered the jewellery from the pawnbroker. If the buyer does not adopt the transaction and the goods are stolen or accidentally destroyed whilst it is in the buyer's possession, property does not pass to him. The owner is still the owner. In other words, the owner has property in goods. But that also means that he, the owner, has the risk in the goods. That's what Section 20, sub 1 says. So the owner bears the loss. We're looking at Section 18, Rule 4, which deals with goods delivered on approval or on a sale or return basis. Rule 4 says property passes in two ways. First of all, when the buyer signifies his approval or acceptance to the seller, or the buyer does an act adopting the transaction. The second way is if, without giving notice of rejection, the buyer retains the goods beyond the time agreed, or if there's no time fixed, beyond a reasonable time, which is always, of course, a question of fact. Example: I offer to sell you my pen on a sale or return basis. Return my pen by tomorrow, 10 a.m. Now, if you do not return my pen by 10 a.m. tomorrow, property passes to you. The case authority, Poole against Smith's Cars. The car owner authorised the dealer to sell it for £325. The deal was that the car dealer's commission would be whatever he sold it for beyond £325. After 3 months, the car was still not sold. So the owner asked for the return of his car within 3 days or give him £325. The car was returned to the owner a few weeks later, badly damaged by one of the dealer's employees who drove it without permission. The court held that the contract was a sale or return. After a reasonable time, property passed to the dealer who was liable for £325. Now, consider this. What happens if you sell me a piano on a sale or return basis and I pass it to my sub-buyer also on a sale or return basis? Have I adopted the transaction between you and me? Well, it kind of depends. There were some useful judgments in Genn against Winkle. The facts of the case don't matter at all. But what the court said was this: if you sell me on a sale or return and I immediately pass it to my sub-buyer on a sale or return on the same terms, property does not pass. That's because if between you and me 10 days is reasonable time for me to decide to buy or return the goods, then 10 days is also a reasonable time between me and my sub-buyer. So if you pass me the goods and I straight away pass to my sub-buyer, everyone has 10 days to buy or return. So I have not adopted the transaction. On the other hand, If I keep the goods for 7 days and then I pass to my sub-buyer, effectively, I have adopted the transaction between you and me, because my sub-buyer has 10 days from when I pass the goods to him. Of course, if he returns the goods before my 10 days is up with you, I can return them to you. Remember, these rules only apply if there is no agreement to the contrary. So if I sell you goods on a sale or return, but I specifically say property will not pass to you until I've been paid, well, the intention is very clear and you don't need to look at Section 18 rules. Okay, so those are Section 18 rules 1, 2, 3, and 4. Remember, rules 1, 2, 3, and 4 only apply to specific goods. Rule 5 is the only one that deals with unascertained goods. Remember, Section 16 makes it very clear that no property can pass unless and until the goods have become ascertained. There is one major exception to that rule, Section 20, Big A. We will deal with Section 20, Big A later this evening. Section 16 is always the starting point for unascertained goods. Property cannot pass until and unless the goods have become ascertained. It does not matter what the parties intended. Unless the goods are ascertained, no property can pass. Once the goods have become ascertained, when property passes depends on the intention of the parties. If the intention is not clear, then you look at Rule 5. Rule 5 is the only one that deals with unascertained goods. There is Rule 5.1, Rule 5.2, and Rule 5.3. So there are 3 bits to it. Let's look at these individually. Now, under Section 18, Rule 5.1, property in unascertained goods passes to the buyer when 4 conditions are satisfied. First, the goods must be of contract description. Well, this is pretty obvious. I don't need to say anything more about that. Secondly, goods must be in a deliverable state. We know what that means. It means goods must be in such a state that the buyer is bound to take delivery of them. Thirdly, goods must be unconditionally appropriated with the seller's or buyer's assent, which may be express or implied, given before or after appropriation. Now, I know that's a bit of a mouthful, so let's break that down. Unconditional appropriation means there must be a clear intention to attach those goods irrevocably to that contract. The very important case is Carlos Federspiel against Charles Twig. This case concerned an FOB contract, free on board contract, for 75 bicycles. The buyer had prepaid for the bicycles in full. The bicycles were packed in cases, in cartons, and they were labeled with the buyer's name. The shipping instructions were given, but the goods were never shipped. They were still in the seller's warehouse when the seller went bust. The receivers took possession of the seller's assets, which included the bicycles. The buyer argued that He had prepaid for the bicycles, so he said he was the owner of them. The court said property had not passed to the buyer for two reasons. First of all, it was an FOB contract, free on board contract. This showed that the intention was that property and risk would not pass to the buyer until the goods were safely on board the ship. The second reason is that the most important and decisive act to be done by the seller was to transport the goods to the port for shipment. This was not yet done. The bicycles were therefore merely set aside. Even though the crates were labelled with the buyer's name, this did not amount to unconditional appropriating the bicycles to the contract. Unconditional appropriation needs to be more than that. Unconditional appropriation needs to be the irrevocable identification of goods. Irrevocable means the seller cannot change his mind. He cannot substitute goods. Irrevocable means goods are put beyond the power of the seller to substitute. Let's look at the difficult case of Aldridge against Johnson. The contract in this case was for some barley. The buyer provided the sacks and the seller filled those sacks with barley. The seller stopped halfway and for some reason emptied the barley out of those sacks back into the bulk. The seller went bust. The question for the court was whether filling the sacks constituted appropriation. The court said yes. When the seller shoveled the barley into the sacks, the court said the barley became ascertained. So goods had become appropriated. Now, this is a difficult case because surely this was not the right decision. I mean, in Carlos Federspiel, there was no appropriation when the seller had packed the bicycles in crates marked with the buyer's name. Whereas in Aldridge, there was appropriation when the seller put the barley into sacks. Aldridge can't be right. There needs to be irrevocable identification of goods. Surely the seller could still substitute the barley. I mean, the only thing we can say is that maybe the court in Aldridge felt that the wording of the contract meant that the parties intended appropriation as soon as the buyer's sacks were filled. You see, the contract term required the buyer to provide the sacks. But even so, putting barley into sacks supplied by the buyer is not really final and decisive, is it? Excuse me. Aldridge is very difficult to reconcile with Carlos Federspiel. It has certainly been criticized, but it stands as a decision. And it's a very old case, 1857. Leave that alone for the moment. Let's look at section 18, rule 5.2. Rule 5.2 says, if the seller delivers goods to the buyer or to a carrier for onward transmission to the buyer, and the seller does not reserve his right of disposal, he is taken to have unconditionally appropriated the goods to the contract. So under Rule 5.2, what it is saying is, if I deliver goods to you, the buyer, this is clearly unconditional appropriation. There is a clear intention to attach those goods irrevocably to your contract. I can't withdraw delivery. So once the goods are in the buyer's hands, I can't grab the goods back. Property passes to the buyer. That's what Rule 5.2 is saying. Property passes to the buyer unless I have reserved the right of disposal under Section 19. We will see Section 19 in a minute. Now, if I deliver to a carrier, to a lorry, or to whatever, if I deliver to a carrier to deliver to the buyer, this is also unconditional appropriation if I don't reserve the right of disposal. But property will still not pass if the goods delivered to the carrier remain unascertained. The case authority is Healy against Howland. This case concerned an FOR contract. FOR means free on rail. You put it on the train. Free on rail contract for 20 boxes of mackerel, a type of fish. The seller put 190 boxes of mackerel fish on the train to go to different customers. He didn't label any of the boxes, but he gave the railway company a list and asked them to drop off a certain number of boxes at different destinations. The train was delayed. The fish deteriorated. Question: whose property? Who did the fish belong to? The seller argued he had unconditionally appropriated the fish by putting them on the train. The court said the fish remained the seller's property. Putting 190 boxes on the train was not unconditional appropriation to any buyer. The fish was still unascertained goods. Property cannot pass. Supposing a different situation. Supposing a buyer is to collect the goods not from the seller, but from a third party. When does unconditional appropriation take place? The case is Wardars against Norwood. The seller had 1,500 cartons of frozen kidneys in a warehouse. He sold 600 cartons to the buyer and he set them aside for the buyer to collect. Well, so far, this is no more than Carlos Federspiel, when 75 bicycles were set aside. Well, the buyer's carrier went to the warehouse with a delivery order. The warehouse official gave the okay for loading to commence. The Court of Appeal said that the goods were unconditionally appropriated when the delivery order was accepted and loading was allowed to start. Now, Rule 5.2 talks about when the seller delivers goods to the buyer or to a carrier, and if the seller does not reserve his right of disposal. Reserving right of disposal means reserving property. This is Section 19. Section 19 says if the seller reserves his right of disposal of goods until certain conditions are fulfilled, property does not pass until those conditions are fulfilled. Example: I send the contract goods to you via a carrier. I tell the carrier, do not hand the goods to you until she pays you cash. I have reserved my right of disposal, so property does not pass to you until you pay, even though the goods have been identified and appropriated to the contract. Now, we're talking about when property passes to a buyer in unascertained goods. 18 Rule 5 sub 1 says property in unascertained goods passes when 4 conditions are satisfied. Goods of contract description in a deliverable state are unconditionally appropriated. Let's look now at the 4th condition, with the seller or buyer's assent, which can be express or implied and given before or after appropriation. Well, what does that mean? Let me make up an example. Let's say my car needs petrol. So I go to a petrol station and I fill the car up with petrol. Question: when does property in the petrol pass to me? Well, if the attendant puts petrol in my car, that is unconditional appropriation with the buyer's assent, because we are attaching the goods irrevocably to the contract. Me, the buyer, I assent because, you see, unless I click that button which allows the petrol cap to open, the seller can't fill up my car. So only when I've clicked that button allowing the seller to fill up my car, that's when the petrol is unconditionally appropriated with my assent. Now, unconditionally appropriated because I am attaching those goods irrevocably to my contract. The petrol is now inside my car. The attendant, the petrol station, can't suck it out. It's irrevocable. Now, if it is a self-service petrol station, when I put petrol in my car, the seller has impliedly assented to unconditional appropriation. Because there's be a man at the window, he looks at me. Then he presses a button to allow me to start pumping petrol into my car. So, property in the petrol passes to me when I put the petrol in. It's irrevocable. Again, no one can suck the petrol out. So property in the petrol passes to me when I put the petrol in. Now, this petrol is an example of when the party gives assent before appropriation. But you can give assent after appropriation. The important case authority is Pignataro against Gilroy. The seller sold 140 bags of rice to the buyer. 15 bags were appropriated, and the seller gave the buyer a delivery note, and he was told when he could come and collect the bags. But the bags were stolen before the buyer collected the bags. The theft was not due to the seller's negligence. The buyer wanted his money back for the 15 bags. Court said no. The buyer's action failed. The seller's appropriation of the bags without objection from the buyer within a reasonable time, that amounted to assent. So title in the bags transferred to the buyer. They belonged to the buyer at the time they were stolen. So what is also clear from this case, that if the buyer knows that the seller has appropriated goods, the buyer cannot delay the passing of property by inaction. There's one more sub-rule which was added by the 1995 Amendment Act. We need to look at Section 18, Rule 5.3. Rule 5.3 essentially deals with ascertainment by exhaustion. This gives statutory authority to the ILAFI. We looked at that case before. Rule 5.3 says, where the buyer agrees to buy goods out of a specified bulk, for instance, buyer agrees to buy 50 tons out of the 300 tons currently in my warehouse, then Rule 5.3 says property passes to the buyer when only the contract quantity, 50 tons, or less than the contract quantity, less than 50 tons, is left in my warehouse if 3 conditions are satisfied. First of all, goods must be in a deliverable state. Secondly, the buyer is the only buyer left. Thirdly, the buyer assents. Now, the buyer assenting is usually implied because if the buyer agrees to buy from a specified bulk, he knows that the business seller will try and dispose of the remaining 250 tons. Of course, if I end up with only 40 tons in my warehouse, although property in 40 tons passes to the buyer will sue me for damages for breach of contract because I did not deliver the full amount. The buyer will be entitled to damages for non-delivery under Section 51, although, of course, there is a duty to mitigate. Now, we will be looking at remedies, looking at damages for non-delivery. We'll be looking at this later on in the syllabus. But of course, remember, there is always a duty to mitigate. So if prices are zooming up, the buyer ought to accept the short delivery and sue for the balance. We will deal with remedies anyway later on, as I say. Can the seller supply the shortfall from elsewhere? The answer is no. It must be a specified bulk, an identified bulk for Section 18, Rule 5.3 to operate. So I cannot supply the shortfall of 10 tons by buying elsewhere because we are talking about a specified quantity of unascertained goods out of an identified bulk, just the second type of unascertained goods. Now, those are the rules as far as passing of property is concerned. Remember, Section 18 only kicks in if the parties do not expressly agree otherwise. But even once property passes to the buyer, property can revert to the seller. Property moves. It's like offer and acceptance. I make you an offer, you make a counter offer. It keeps moving. Property is the same. Example, I sell you a defective TV. You own the television set, but if it is defective, if it blows up on you, you want to reject. Well, fine. What is it you are rejecting? The answer is property. That's what you were paying for. You were paying for property. That is the whole point about the sale of goods contract. That's what Roland against Duval said. We'll look at that case in a minute. So when the buyer rejects the goods, the buyer is rejecting property. This means property reverts to the seller. It now belongs to the seller. So property, as I say, moves. Now, as I said before, the transfer of property rules, everything we've just discussed, are exactly the same, whether it's a B2B contract or a B2C contract. The Consumer Rights Act, the CRA, does not make any provision about the transfer of property. So the rules we've just talked about apply to consumers. But it's a problem, isn't it? I mean, The transfer of property rules are really quite complex. I mean, we talk about goods in a deliverable state. We talk about unconditional appropriation. How can an ordinary consumer understand those rules? The bigger problem, I think, is that consumers usually prepay for goods before they are delivered, especially nowadays when we are buying so many things online. We pay first, then the goods are delivered later. What happens if the seller goes bust? Who owns the goods? This is a bigger problem for consumers than for business buyers. Business buyers often buy on credit. They haven't paid for the goods yet. So if the seller goes bust, it's less of a problem for the business buyer because he hasn't yet paid the invoice. But it is a real risk for you and me, a real risk for consumers who have prepaid for goods. If the seller goes bust, the liquidators claim the goods. So the consumer is left with no goods, no money. That's why the Law Commission a few years ago proposed that consumers have their own transfer of property rules. And they drafted a bill to amend the Sale of Goods Act and the CRA. The Law Commission wanted to simplify the rules so that property passes to the consumer much earlier than for business buyers. The Law Commission suggests that property passes to the consumer buyer essentially at the time the contract is made. You see, in this way, if the seller goes bust, the consumer buyer can claim the goods, not the liquidator. Of course, we don't know whether the Law Commission's proposals will be implemented. We just have to wait and see. But it is a real problem because so many of us buy things online. Statistics show that online sales has doubled since COVID. Now, if I go to a shop and I buy goods, I pay for it, I take the goods home, no problem. The deal is done. It doesn't matter if the seller goes bust 2 seconds later. I have the goods already. It's because so many of us are buying things online that it is a problem if the seller goes bust. We've paid for goods, but because the Sale of Goods Act rules say property remains with the seller, the liquidator gets the goods and the consumer basically ends up as an unsecured creditor. There is almost no chance of getting any money back. So there are proposals that consumers have their own transfer of property rules. Whether they get implemented, as I say, is another matter. Okay, let's move on. We've looked at when property is transferred. Let's look at the transfer of risk. The starting point is section 20, subsection 1. Risk passes with property unless parties agree otherwise. So section 20 sub 1 is saying is whoever has property in goods has the risk. So it is the owner who has to bear the loss. So if I'm the seller and I have reserved my right of disposal in goods under section 19, I retain property in goods until I get paid. Risk is on me. So if goods are stolen, risk is on me. It'll be the seller's loss. Does not matter who has possession of the goods at the time of loss. Note that section 20 sub 1 is subject to 2 exceptions, 20 sub 2 and 20 sub 3. 20 sub 2 exception says, Where the delivery is delayed through the fault of the seller or the buyer, the goods are at the risk of the party at fault. Case authority, Denby Hamilton against Barden. This case concerned 30 tons of apple juice. The buyer was delayed taking delivery. By the time he did take delivery, the juice had gone bad. The court said, buyer bears the loss. It was the buyer's fault that he was delayed in taking delivery. The second exception is section 20 sub 3. This essentially says normal Bailey duties apply. In other words, the person in possession must take reasonable care of the goods, even if property is with the other party. So let's say if it was my negligence, I left the warehouse doors wide open, and that's why thieves got in and stole the goods. I mean, for instance, in Pegnataro against Gilroy, the case we just looked at, if it was the seller's fault, he left the doors open, and that's why 15 bags of rice were stolen. Even if property had transferred to the buyer, risk is with the seller, the person who did not take reasonable care of someone else's goods. We already said that the consumer has a different rule under the CRA. Section 29 of the CRA says goods are at the trader's risk until actual delivery to the consumer. This does make sense. Usually, the consumer's insurance, if he has insurance, only kicks in once he has taken possession of the goods he has purchased. There is one exception to that. If the consumer arranges his own carriage of goods, the risk passes to the consumer when the trader delivers the goods to the carrier. All right, that's just a little mention of B2C contracts. Let's get back to our B2B situations. The general rule is risk passes with property. But section 20 sub 1 specifically says unless the parties agree otherwise. This means the parties can decide for themselves, subject, of course, that it must be agreed at or before the contract is made. The usual common law rules as far as incorporation apply. But sometimes it is difficult to know what the parties agreed. Stearns against Vickers is a very important case. The seller owned 200 gallons of white spirit stored in a third-party warehouse. The seller sold 120 gallons to the buyer. The seller gave the buyer free storage at the warehouse until the 31st of January. The buyer was to make arrangements for storage after that. The seller gave the buyer a delivery note so that the buyer can collect at any time up to the 31st of January. But the buyer did not collect for ages, well after the 31st of January deadline. The white spirit had clearly deteriorated. Question for the court was, whose risk? The Court of Appeal said property did not pass because until 120,000 gallons, until collection, the 120 gallons remained unascertained. But, the court said, the parties intended for risk to pass to the buyer when the buyer accepted this delivery note. So it was at the buyer's risk. Now, what is clear from this case is that risk can pass before property. But the difficulty is that court is saying is court is saying risk in unascertained goods can pass, even though property cannot. Not has not, but cannot. Not until the goods have become ascertained. That's section 16. So it's very tricky, the situation. Now, in Stearns against Vickers itself, the entire tank of 200 gallons had deteriorated. So both the seller and the buyer lost out. But supposing only half the tank deteriorated. If you look at the diagram on the screen, let's say only 100,000 gallons deteriorated. How would the loss be allocated between the seller and the buyer? I mean, the seller would argue the buyer bought 120,000 gallons, so the buyer bears the loss of 100,000. The buyer would argue the opposite. In other words, the buyer bought 120,000 gallons and 100,000 gallons are okay. So the maximum the buyer risks is 20,000 gallons. Who's right? Well, presumably the loss is allocated between the seller and the buyer pro rata. In other words, the buyer would bear 120 divided by 200. In other words, he would bear 3/5 of the loss. Now, this was never very clear before, but now the position is a lot clearer with the 1995 Amendment Act. This is section 20, big A exception. Now, whenever I say big A, big B, the reason why I say big A, big B is because it's an amendment. All right, so the original Sale of Goods Act didn't have 20 big A or 20 big B. It was just section 20 or section 20 sub 1. Big anything means it is something which was added by an Amendment Act inserted into the original legislation. We're going to look at the section 20 big A exception now. Now, under the transfer of property rules, we said section 16 is the starting point. 16 says property in unascertained goods does not pass to the buyer unless and until the goods have become ascertained. There's one very important exception. This is the section 20 big A exception. 20 big A deals only with the second type of unascertained goods. Specified quantity of unascertained goods out of an identified bulk. So it only deals with a situation like 100 tons out of the 500 tons in my warehouse. You see, 20 big A was inserted as an amendment to the Sale of Goods Act because lots of businesses complained after a Dutch case in 1985 called the Gosforth. The Dutch court heard the case. English law governed the contract. The buyers had prepaid for goods on board a ship, but the goods remained in one bulk. In other words, the goods were unascertained. The seller's creditors demanded the goods. The court confirmed section 16. The court said property in goods does not pass to the buyer because the goods remained unascertained. That was the operation of section 16. Even though the buyer had prepaid for the goods, the seller's creditors were entitled to all of it. Now, section 16 has been around a very long time, but this case hit a raw nerve with everyone. There was massive publicity. The parties in the Gosforth, they chose English law to govern the contract. Because of this case, the parties other people started looking at alternative laws. For instance, German law, which would have given the buyer ownership in common of the bulk. Now, this posed a huge threat to the shipping business in Britain. So the Law Commission recommended the change, and Section 20 Big A was inserted as an amendment to the Sale of Goods Act by the 1995 Act. Commercial people wanted this change. You see, Section 16 is not simply a rule of law. It's a fact of life. I must be able to identify what I say I own. It cannot be right for me to claim goods which are unidentified, which are wholly unascertained. It is not sufficient that the bulk is identified. You can't tell, for instance, in Re Gold Corp, one of the cases we looked at yesterday, you can't tell which bit of the gold bullion is mine. The contract quantity in the bulk must be unconditionally appropriated to my contract in order for me to say those are my goods. Maybe by dispatch by an independent carrier, because it places goods outside the seller's control. You see, the effect of Section 16 was that if I paid in advance for 99 bottles of wine to be supplied from a stock of 100 bottles, and the seller goes bust, I cannot claim ownership of even one bottle, because I cannot say which one bottle out of the 100 was not meant to be mine. Because of that one bottle, I am then merely an unsecured creditor. But if before the seller goes bust, one wine bottle rolls off the shelf and is smashed, wow, I am now the owner of the remaining 99 bottles. Why? Because goods have become ascertained by exhaustion. Section 18, Rule 5.3, the ELAF. Or I could have avoided the problem in the first place if instead of buying 99 bottles, I agreed to buy 99% of your 100 bottles. That's because an undivided share specified as a percentage or fraction is specific goods under Section 61. Now, this distinction is so technical, so convoluted, that Section 20 Big A was brought in as an amendment. Business people wanted this change. Let's look at this exception now. It gives the buyer who has paid for goods before delivery some measure of protection if the seller becomes involved. Section 20 Big A says, where the buyer pays the price or part of it for a specified quantity of goods from an identified bulk, the buyer acquires property in an undivided share. He becomes an owner in common of the bulk. Now, it's a kind of statutory tenancy in common. Section 20 Big A is complex. I think that is a good place for us to take a break. When we come back, I'll show you how Section 20 Big A works. So let's take a 10-minute break. All right, I'll see you later. Hi, okay. We're going to look at section 20, big A. Let me show you how it works. Take a look at the diagram on the screen. I have 1,000 tons of something in my warehouse. I sell you 200 tons out of the 1,000 tons in my warehouse. We know under section 16, property cannot pass to you until the goods have been ascertained. What section 20 big A is saying is if you have paid for the goods, assuming, of course, you and I don't agree anything about the transfer of property. If you have paid for the goods, you now own 20% of my 1,000 tons. In other words, 200 divided by 1,000 tons. Let's say that before you take delivery, I sell 500 tons to another customer who takes delivery. Now, I only have 500 tons left in my warehouse. Remember, you bought 200 tons. You now own 40% of 500 tons left. 200 divided by 500. Now, of course, if I actually sell all my tons, leaving only 200 tons left, you own 100% of it. And property passes to you because of section 18, rule 5.3. Rule 5.3, if you remember, says property passes to the buyer if there is the contract quantity or less than the contract quantity left in the bulk in a deliverable state. And the buyer is the only buyer left, and the buyer ascends. This is essentially the ELAFI. Let's be really, really clear about section 20, big A. 3 conditions need to be satisfied. First condition, specified quantity. Section 20, big A only applies when the contract is for the sale of a specified quantity. It must be 100 tons, 200 litres. It does not apply if the contract is for half or 50% of the wheat in my warehouse. Second condition, it must be an identified bulk. So 20 big A only applies where the parties have an identified bulk source. What's the definition section number in the Sale of Goods Act? Can you remember? If you don't know the definition, if you don't know what this word means in the Sale of Goods Act, you go to the Sale of Goods Act, one section number is the definition section number. Can you remember what that definition section number is? Very close, close enough. I'll give you the mark. It's section 61. Very good, well done. So if we're talking about an identified bulk, remember the parties must have an identified bulk source. Now, if I go to section 61, the definition section, bulk is defined as a collection of goods of the same kind, which is contained in a defined space, and the goods are fully interchangeable. In other words, the bits are all the same in the bulk. Now, the parties can identify bulk source either at the time of the contract or subsequent. Example, I agree to sell you 100 tons of wheat. Now, this is wholly generic, unascertained goods. I didn't say where I'm getting it from. I just agreed to sell you 100 tons of wheat. This is generic, unascertained goods. So section 20, big A will not apply. But after the contract, You and I agree that the 100 tons is going to be from a named ship or from a particular warehouse. Well, now section 20 big A will apply, assuming, of course, the other conditions are satisfied. The third condition is that the buyer must have paid for some or all of the goods. The buyer must have paid something. So the size of the buyer's share of the bulk depends on the quantity of the goods he has paid for and the quantity of the bulk at that time. Now look, I know the diagram looks tricky, but it's not. It's exactly the same as we looked at just 2 minutes ago, but I've just added to it. For example, we've already said, I sell you 200 tons out of the 1,000 tons in my warehouse. If you paid in full, you now own 20%. I then sell 500 tons to another customer. If you paid in full, you now own 40% of the remaining bulk. All I'm adding now is that if you only paid half the invoice, you own 20% of the bulk. That's because the percentage you own of the bulk depends on what I've got left in the bulk at any particular time, and it depends on how much of the invoice you paid. But the important thing is, once all three conditions have been satisfied, the buyer becomes the owner of an undivided share of the bulk, as owner in common with the seller and or any other buyers. So section 20 big A gives a buyer who has paid for goods before delivery some measure of protection if the seller becomes insolvent. Now, the losers from section 20 big A are, of course, the seller's unsecured creditors. But then they're not really losers because section 20 big A only applies to prepaid goods. It used to be an unjust enrichment, actually. Not only did the seller get paid in advance, but if he goes bust, his creditors get to keep the goods too. That's unfair. Why should the seller's creditors be unjustly enriched? The seller effectively used to get a double benefit. But what about risk? What about risk? Well, when section 20 big A applies, it is not clear whether risk passes to the buyer when he acquires this undivided share, or he only gets property later by ascertainment and appropriation. The Sale of Goods Act does not actually deal with this point. The 1995 amendment forgot to say anything about risk, but this is crazy because risk is more important to business people than property in many ways. Now, there are arguments for and against risk passing to the buyer. There are arguments for risk passing to the buyer when the buyer acquires an undivided share. Some say risk passes to the buyer at that time. There are two arguments for risk passing to the buyer. First, res perit domino. This is just a Latin phrase that says risk is borne by the owner. Res perit domino. The second argument they use is Stearns against Vickers. There are arguments against this. In other words, risk remains with the seller. One argument against is based on section 20, big B, sub 3. Again, when I say big anything, it means it was an amendment. So those who argue against risk passing to the buyer, they say they base their argument on section 20, big B, sub 3. because 20 big B sub 3 says nothing in this section or section 20 big A shall affect the rights of any buyer under the contract. Now, we're not really sure which of these arguments is preferred. Probably the better view is against. In other words, the seller alone bears the risk of any loss or damage to goods in the bulk, even if the buyer has undivided share until the goods are delivered to the buyer after appropriation. The basis of this is that the reason why it's preferred view is because section 20 big A only says the buyer is an owner in common. It doesn't mean he has full-blown property. Risk should not pass to the buyer at that time because the buyer is still entitled to his contractual rights of delivery of goods which conform to the contract as far as quantity and quality is concerned. So if the bulk is part destroyed, the loss should be borne by the seller. If you look at the diagram on the screen, the bottom picture, example, I have 500 tons in my warehouse. You buy and you pay for 200 tons. Now, if 250 tons is destroyed or 250 tons is mine, the seller's loss, you now own 200 tons out of the remaining 250. In other words, 80% of the bulk. But what happens if other buyers are involved? What if what is left in the tank or the warehouse or the whatever is not sufficient to satisfy all the buyers? Well, that's where section 20 big A sub 4 comes in. 20 big A sub 4 says each buyer's share is reduced accordingly. What is interesting is that section 20 big A4 does not say anything about the seller. What that means is if the seller owned any of it, the seller loses his goods first. What is left is then split amongst the co-buyers in proportion. If you look at the top diagram on the screen, the example is seller owns 500 tons. He sells buyer number 1 200 tons. He sells buyer number 2 200 tons. Supposing 300 tons are destroyed, that means there are only 200 tons left. Who bears the loss? Well, the loss of 300 falls on the seller. That's fair enough. But there's only 200 tons left. How do we split this between buyer 1 and buyer number 2? The answer is that the 200 will be split amongst the co-buyers in proportion. So now buyer 1 owns 100, buyer number 2 owns 100. The quantity to be delivered is reduced according to what was paid and what was left in the bulk. The seller is not entitled to any of it. That's the effect of section 20A4. There are exceptions to this, of course. First of all, Stearns against Vickers, which we mentioned before. In other words, where the parties agree otherwise. The second exception is where it is one party's fault that there was a delay. Again, we've looked at section 20 sub 2. Let's say my entire warehouse blows up. If all the goods are destroyed, then the answer is the contract is frustrated. Usually, the entire contract is frustrated. That's what Hilji Mulji against Cheong Ye Steamship said, because there is nothing left to affirm. But remember the dodgy decision of Sainsbury against Street. That was the contract for 275 tons of barley to be grown on a particular farm. These were unascertained future goods. Because of a disease, only 140 tons were produced. The court suggested that where only part of the goods did not materialize, in other words, only part destroyed, frustration only affects that part that was destroyed. The seller was still obliged to offer the remaining goods to the buyer, even though the buyer does not have to accept partial delivery. This, we said, is a bit odd. In other words, the seller must offer, but the buyer does not have to accept. It is the buyer's option. But the case was before the amendment to section 30 sub 1, which allowed the buyer to reject a smaller quantity of goods delivered. Now, 30 sub 1 has now been amended so that a buyer cannot reject if the quantity delivered is just a small difference. The amendment is section 30 to big A. There is a duty to mitigate, of course. So if the price of the goods is going up, the buyer should accept a smaller quantity. We looked at this already. Back to our exception to section 16. To facilitate dealings in goods by co-owners, section 20 big B was brought in. 20 big B says each co-owner is deemed to consent to delivery or removal of goods to another co-owner. Section 20 big B is complex. Read it in your own time. But the main effect of 20 big B is first come, first served. If the buyer takes delivery of goods, then he ceases to have a share in the bulk. Only the remaining buyers are the co-owners of what is left. 20 big B says if the buyer takes delivery of goods, the other co-owners cannot complain. First come, first served. This is true even if a buyer has taken more than his share, technically. See the bottom diagram on the screen. Example, I have 1,000 tons in my warehouse. I sell to buyer number 1 200 tons. Buyer number 1 now owns 20%. I wrongfully sell to buyer number 2 900 tons. But buyer number 2 actually takes delivery of 900 tons. Buyer number 2 has taken more than technically his share allows. But what 20B is saying, buyer number 1 cannot claim, cannot recover against buyer number 2 under 20 big B, because buyer number 1 is deemed to have consented to early delivery to other co-owners. What is buyer number 1 going to do? You tell me. Buyer number 1 cannot sue buyer number 2 because 20 big B says first come, first served. Whoever takes delivery, bang, you're okay. So buyer number 1, of course, he bought 200, but now he's only got 100 left. You tell me, what's buyer number 1 going to do? Can't sue buyer 2. You tell me, what's buyer number 1 going to do? You tell me. Absolutely correct. Thank you very much. He is certainly going to be suing the seller for damages. Damages for short delivery. But of course, this would be worthless if the seller had gone bust. Now, if the seller sells more than the availability is in bulk, title to the goods delivered to buyer number 2 is subject to section 24 exception of Nemo Dat. Second sale by seller in possession. Don't worry too much for the moment about section 24 Nemo Dat exception. because we're going to be studying Nemo as a whole topic in its own right. Now, when buyer number 2 or any other buyers take delivery of the goods become ascertained and property can pass to the buyer. Remember again, Section 18, Rule 5.3, the ILAFI. If there is only one buyer left and the bulk is the quantity or less than the contract quantity, goods are appropriated to the contract and property passes to the buyer. Now, that completes the passing of property and risk section of our syllabus. It is fairly complex. So I did say, of course, that we would look at a sample exam question after every topic. So let's do just that. Let's see how these questions turn up. Let's look at the question on Patsy. Now, this question is on page 20 of your lecture handouts, all right? It's on page 20, so you can probably be easier to read from your handout. What I'm going to do, and what I always will do, I will read the question out loud once. I will then give you 1 minute to reread the question, and then we'll immediately get down to do the rough work. So I'll read it out loud with you once, and I'll give you a minute to reread. This is on page 20 of your handout. Let's do with Patsy. Let's read this together. Patsy is a retailer. She goes to a dairy wholesaler, Dairy Wise, to purchase milk, eggs, and cheese. She places the following orders, all of which are paid for. She selects 60 boxes of eggs from the shelf and takes them to the till. It is agreed they will be delivered with the rest of the order. She selects a packaged 30 kilograms of cheddar cheese from the refrigerator and takes it to the till, where it is agreed that Dairy Wise will cut up and package the cheese into 60 times 500 gram packs before delivery. She orders 100 tons of milk. The cashier tells her that all of the fresh milk is stored in a large 1,000-litre storage tank in the dairy warehouse. It is agreed that Patsy will acquire 100 litres from the 1,000 litres in the tank. The following day, Patsy received a phone call from the manager at Dairy Wise, who told her the eggs had gone missing from the delivery area of the warehouse. The cheese had been cut up and packaged and left in the delivery area of the warehouse, but had also gone missing. When they extracted 100 litres of milk from the storage tank, they discovered that it had gone off and was not safe to drink. Advise Patsy on property and risk for each of the products. Very standard question. Let me give you a minute just to reread this, and then we'll do the rough work. Give you a minute to reread it. Okay, well, I hope that was enough time for you to reread the question. Now, this question says, advise Patsy on property and risk. I mean, to be frank, Patsy really only wants to know about risk. I mean, in this question, the goods have gone missing or are destroyed. So the question is, who must bear that loss? The answer is the person with risk. It's because the parties hardly ever agree to anything about risk that we need to see when property passes between the seller and the buyer. Because section 20 sub 1 says risk passes with property. So when goods have blown up, like in this question, or gone missing, the answer involves transfer of property and risk. When the seller's just gone bust, it's purely a transfer of property. But in this question, goods are missing or destroyed. So the answer involves both property and risk. One of the points you need to make in the introduction to your answer is you should point out that this is not a CRA situation. That's because Patsy is not a consumer. She's a retailer buying goods for business purposes. Businesses can never be consumers, so it's not the CRA. The Sale of Goods Act applies. Of course, only risk is different anyway. If it was a consumer contract, then section 29 CRA applies. CRA applies, and this answer will be far too short. Whereas under the Sale of Goods Act, the general rule is set out in section 20 sub 1. The first thing to do in answering a question like this is, in your rough work, you have to work out what type of goods your client has agreed to buy. We need to work out what type of goods we are dealing with because, as you know, the transfer of property rules are completely different depending on whether goods are specific goods or unascertained goods. So the first thing to do is to work out what type of goods our client Patsy, the retailer, has agreed to buy. The relevant time is when the contract is made. Okay, so I'm going to ask you, so what about the eggs? Patsy selects the eggs from the shelf. She takes them to the till. What type of goods has Patsy agreed to buy? You tell me. There are only two types of goods in the whole world. Why don't we shorten S for specific, U for unascertained goods? So what type of goods has Patsy agreed to buy? What are the eggs? Thank you very much. Correct, I agree. So these eggs are specific eggs, specific goods. Very good. What about the cheese? Patsy takes the cheese to the till. The seller is to cut it up and package it. What type of goods is the cheese? You tell me. What type of goods is the cheese? You tell me. Specific or unascertained? Thank you very much. Correct, I agree. The cheese is specific goods. What about the milk? Patsy orders 100 tons of milk. What type of goods is the milk? Specific or unascertained? Excellent. I agree with you. The answer is unascertained goods. Now, exam technique tells you it cannot be specific goods because the eggs and the cheese are specific goods. There is no way, I can guarantee it, there is no way we are going to give you three goods the same type. So the milk is definitely unascertained goods. So the first thing to do in rough work is to work out what type of goods the exam question involves. In this question, there are two specific goods and one is unascertained goods. So the mix is kind of right. So if, having done that, you have 3 of the same type of goods for sure. You've gone wrong. So now you've decided on the type of goods, 2 are specific, 1 is unascertained, then work out what the main issues are. We're just doing rough work. I'm not going to write down the full answer. I just want to write down the main points I need to discuss when I am writing my answer. So take each of these in turn. Now, as far as the eggs are concerned, we said the eggs are specific goods. So we're trying to find out property and risk. So question is, when does property pass in specific goods? What is the starting point? When does property pass in specific goods? There is only one way to start that. What's the section number, which is the starting point for specific goods? Can you remember? Very good. Excellent. Section 17. Thank you. So section 17 is always the starting point. That's supposed to be, let me try again. Okay, section 17 is the starting point. Section 17 says, property passes when the parties so intend. So it clearly depends on what the parties' intentions are. And you know that you look at 3 things, all right? Now, look at 3 things. Exam technique, of course, tells you that intention is not clear. So you need to look at the section 18 rules. Which is it in Patsy's case? Which rule? Now, if you're not sure which rule, then you just go through a process of elimination. You know that with specific goods, if the intention is not clear, it's either rules 1, 2, 3, or 4. So which rule do we need to discuss? If you're not 100% sure, always do it by a process of elimination. Now, what's rule 4? Rule 4 is where the seller sells goods to the buyer on a sale or return basis. Well, it's nothing like that in Patsy's case. So it's not rule 4. What's rule 3? Where specific goods are in a deliverable state, but the seller has to weigh it to ascertain price. Property will only pass to the buyer when that thing has been done and the buyer has notice of it. Well, it's nothing like that with the eggs, is it? So it's not going to be rule 3. So it's either going to be 18 rule 1 or 18 rule 2. So which is it? Rule 1 or rule 2? The eggs are in a deliverable state. So the answer is we're looking at 18 rule 1. Thank you. Correct. I agree. As far as the cheese is concerned, we said the cheese was specific goods. By going through the process of elimination, you can easily work out it's not rule 3, it's not rule 4. So it has to be either 18 rule 1 or 18 rule 2. Now, exam technique tells you it cannot be rule 1 because the eggs is rule 1. So the cheese has to be rule 2. Not just because exam technique tells you, but we're told that dairy-wise has to do something to the cheese first before delivery. So the cheese is not in a deliverable state. It is definitely rule 2. What about the milk? Now, Patsy orders 100 litres of milk. We said the milk was unascertained goods. So when does property pass in unascertained goods? What is the starting point? It's always one section number. What is the starting point about property with unascertained goods? Thank you very much. Fantastic. That is the correct answer. Section 16 is always the starting point. property cannot pass until and unless the goods have become ascertained. So the big question is, did the milk remain unascertained, or did it become ascertained in some way at the time of the loss? You see, if the milk remained unascertained when it was destroyed, the milk was still totally identifiable at the time of the loss, then it's the seller's problem. If, on the other hand, the milk has become ascertained in some way, identified in some way, either because the goods have been put aside, or they've been put on a lorry, or identified in some other way, then the answer depends on whether Section 18, Rule 5 is satisfied. Now, in this question, it sounds as though the milk remained unascertained. No one put the milk aside before it had gone off. Patsy's 100 litres was still in the tank, mixed with all the other milk. Nothing had happened to it yet. So I think unascertained milk remained unascertained milk. So when does property pass in unascertained goods? We said Section 16 is clear. Property cannot pass until and unless the goods have become ascertained. So are we saying the milk remains unascertained? Because if that's the case, this means property hasn't passed to Patsy. So the risk hasn't passed either. Is that the answer then? Ah, very good, thank you. If Patsy has not paid anything, then yes, only Section 16 is relevant. But if a buyer has paid, then what do we need to discuss? Thank you, very good. Section 20, big A. Has Patsy paid? The answer is yes, she has paid. We're told that. So not only are we talking about property passing, we need to discuss 20 big A risk. 20 big A risk is the much harder bit. So watch out for it in the exams. The chances of it coming up in the exams is super high. Okay, now we've done the rough work. What we're saying is, if she hasn't paid, then Section 16 remains the rule. If she has paid, then we're talking about 20 big A and risk. 20 big A and risk. Okay, well, the neater version of the rough work of what I was trying to draw up is on this page now. Now let's do the answer in full. As far as the eggs are concerned, we said these are specific goods. This is because Section 61 is satisfied. You've always got to go through the basics. So with your exam question, you've got to explain why these are specific goods. You've got to explain it's because Section 61 is satisfied. Specific goods are goods which are identified and agreed upon at the time the contract is made. Patsy herself selects the eggs. When does property pass in specific goods? Well, Section 17 says property passes when the parties so intend. Look at three things to work out what the parties' intentions are. You look at contract terms, you look at the circumstances of the case, and if it is unclear, then you look at Section 18 rules. Well, exam technique will also tell you, even if you think the intention is clear, we want you to say it's not clear because we want you to talk about 18 rules. So you say, yes, well, the eggs appear to be in a deliverable state. So Section 18, Rule 1 applies. Rule 1 says, where there is an unconditional contract for specific goods in a deliverable state, property passes when the contract is made. It is immaterial that delivery or payment is postponed. Then go through each bit and explain each phrase. Unconditional contract means it must be a contract which does not contain a condition preventing Rule 1 from applying. Go through the case of Varley against Whip. This is the case about the reaping machine, which the seller did not yet own when he agreed to sell it to the buyer. Court said this was not an unconditional contract. So 18, Rule 1 cannot apply. Property cannot pass to the buyer under Rule 1 because there was a condition attached to the contract terms. Deliverable state. Say that Section 61 defines this to mean goods must be in such a state that the buyer is bound to take delivery. I gave you two cases. Go through the important case of Underwood against Burr Castle. This case involved a condensing machine. It weighed 30 tons and it was embedded, it was stuck in concrete. The seller sold the machine to the buyer on FOR terms, free on rail. This meant the seller needed to detach the machine and get it to the train to deliver it to the buyer. The Court of Appeal held that Section 18, Rule 1 did not apply because the machine was not in a deliverable state at the time of the contract, because it was stuck to the concrete base. We also know the case of Kulkarni against Manor Credit. The number plate to a brand new Mercedes was only attached to a car when it was delivered. Court said a car without the plate is not in a deliverable state because the buyer is not bound to take delivery of it. Rule 1 also says it is immaterial that payment or delivery is postponed. Go through the case of Dennant against Skinner. This was the case about the buyer buying a van in an auction. The auctioneers asked him to sign a contract to say property in the van would not pass to the buyer until the buyer's check cleared. When the check bounced, the auctioneers argued that they had specifically agreed that property was not to pass until the check had cleared. The court said the statement was only signed after the contract was made, so it was too late. Property had already passed to the buyer at the fall of the hammer. So if the eggs are in a deliverable state, it sounds as though property passes at the time of the contract under Rule 1. So property passed to Patsy. We're told the eggs have gone missing. So we need to know who has risk. Well, we've just worked out that Patsy has property. So now discuss risk. Section 20 sub 1 says, unless otherwise agreed, risk passes with property. Well, unfortunately, this means that our client Patsy has risk. That means Patsy bears the loss. Don't end there. Remember, there are two exceptions to Section 20 sub 1. I can tell you now, we will hardly ever prompt you in the exam question, but you are expected to go through the exceptions to check they do not apply to your exam question. Section 20 sub 1 says risk passes with property, sure, but the two exceptions are 20 sub 2, 20 sub 3. 20 sub 2 says where delivery is delayed through the fault of the seller or the buyer, goods are at the risk of the party at fault. We know the case of Denby Hamilton against Barden, the apple juice that had deteriorated. Section 20 sub 3, normal Bailey duties apply. Now, in other words, if you are in possession of the goods, you must take reasonable care of the goods. Now, in this question, just say that you don't have enough information to conclude whether the exceptions apply, because you're not given any further information. but you will get that bonus mark for mentioning that you have thought about those exceptions, but you just don't have enough information to advise further on that. So, unfortunately, if section 20(1) applies and the exceptions don't, Patsy, our client, has to bear the loss. We're told she has already paid for the eggs. Well, just tell her she is not entitled to her money back from Dairywise. Hang on a second. What about section 7? Might section 7 apply to avoid the contract? Because if the contract is avoided, our client gets her money back. Section 7 does not apply. Why? Because risk has already passed to Patsy when the goods perished. Normally, I would say something about perish, because here the eggs have gone missing. Is missing the same as perished? But you see, I'm going to discuss this for the cheese, because missing is more relevant under Rule 2. Leave that for the moment. Let's move on to the cheese. Now, as far as the cheese is concerned, we know we're talking about specific goods. We already did that in the rough work. So the starting point is section 17. We conclude the intention is not clear, but the cheese this time is not yet in a deliverable state, because the cheese needs to be cut up and individually packaged before delivery. The case is Underwood against Burgh Castle. Now, there's no need to give facts, of course, if you've already given it when you discuss the eggs. Cheese is not yet in such a state that Patsy is bound to take delivery. So 18 Rule 2 says, if goods are not yet in a deliverable state, property passes when that thing is done and the buyer has notice of it. Now, we're told in this question, aren't we, that the cheese has been cut up and packaged. Now, even if the cheese was now in a deliverable state, we are not told, are we, if Patsy was told about it. Patsy had no notice. Always say that notice means actual notice, so Adams and Lindsell can never apply. This means if our client did not have notice that the packaging was done, this means property remains with Dairywise. It means the risk is still with Dairywise. Risk had not yet passed to Patsy. This means the missing cheese is Dairywise's loss, not our client's. But what happens to the contract? Patsy, our client, has a contract to buy cheese. Sure, the loss falls on Dairywise, but what happens to the contract itself? Might section 7 apply? Section 7, to remind you, says, where there is an agreement to sell specific goods, and then, without anyone's fault, the goods perish before risk passes to the buyer, the agreement is avoided. If it is avoided, it means the seller does not have to deliver and the buyer does not have to pay. Now, we are told that the cheese has gone missing. Has the cheese perished? There is no clear meaning of perish for section 7 purposes. We did say when we were discussing this that as a practical matter, if there's no prospect of recovering the goods should be treated as perished. Barrow Lane against Phillips, if you remember, was a case on section 6, but you can use it to apply it to section 7. Section 6, if you remember, says, where there is a contract for the sale of specific goods, and the goods without the knowledge of the seller, where the goods have perished at the time the contract was made, the contract is void. If you remember, Barrow Lane against Phillips involved a specific lot of 700 bags of nuts lying in the seller's warehouse. Unknown to the seller and buyer, 109 bags were already stolen. The court said Section 6 would apply and the contract was void. The court treated stolen goods as commercially perished. We also know the case of Aspar against Blundell, where the Court of Appeal said dates soaked in sewage had perished because you can no longer buy and sell those goods as dates, commercially perished. Back to our client Patsy. Cheese has gone missing. So we think, yes, cheese has perished before risk passes to Patsy. So I think the contract is avoided under Section 7. I think Section 7 does apply. We are told that Patsy already paid for the cheese. So finish this bit off by saying that Patsy, our client, is entitled to get her money back. There will be no Section 51 damages because the contract has been avoided under Section 7. We will discuss Section 51 damages when we look at buyer's remedies. But remember, there are no 1943 Act remedies available to dairy-wise because Section 2, subsection 5 specifically says that the 1943 Act does not apply if the contract is avoided under Section 7 Sale of Goods Act. So dairy-wise cannot claim expenses for cutting up the cheese and packaging them. It is dairy-wise's loss. Don't finish there. Just one more thing to query. The cheese went missing. Is this dairy-wise's fault? Remember, Section 7 only applies if goods perish without anyone's fault. So if Section 7 does not apply because it is dairy-wise's fault and the contract is not avoided, our client Patsy is still entitled to delivery of her cheese. Otherwise, Patsy can sue the seller for Section 51 damages for non-delivery. That is the answer to the cheese. Note, please, if Rule 2 is involved, you invariably, 99.9% of the time, you need to query whether Section 7 applies. Section 7 doesn't normally come into the discussion on Rule 1 because property and risk passes to the buyer at the time the contract is made under Rule 1. But with Rule 2, usually the exam question involves the seller having to pack the goods. Even if the seller has packed the goods, if the buyer has no notice that the packaging has been done, it means property does not pass to the buyer. That's why whenever Rule 2 is involved, you need to query whether Section 7 applies. It's exam technique. Just always query it when Rule 2 is involved. Okay, let's now move on to the milk. We're told Patsy buys 100 litres out of 1,000 litres in the tank. We already identified that these are unascertained goods. That's because Section 61 is not satisfied. The milk was unascertained when Patsy made the contract. The milk remained unascertained when the loss occurred. Nothing had happened to the milk yet. It was still swilling around in the tank with the rest of the milk. The starting point is Section 60. Property in unascertained goods does not pass to the buyer unless and until the goods have become ascertained. Go through re-weight. I'm not going to remind you of the facts now, but you know the case of re-weight. It is not sufficient that the bulk is identified. Then go through re-gold call. Remember, the gold bullion was stored in the company's vaults. They were sold to the buyers, but the company went bust. There was insufficient gold to meet all the buyers' entitlements. The buyers claimed property rights over the gold. Privy Council said no. The gold bullion was unascertained goods. Property cannot pass to any of the buyers because the goods remained unascertained. The one exception to section 16 is 20 big A. We're told Patsy has paid for the milk. That's why section 20 big A exception might apply to Patsy's case, because she did agree to buy a specified quantity of unascertained goods out of an identified bulk. 20 big A says the buyer acquires property in an undivided share and becomes owner in common of the bulk pro rata. Go through the three conditions. The first is that the buyer buys a specified quantity of goods. Tie it into your question. Say here, yes, first condition is satisfied because Patsy agreed to buy 100 litres. Second condition is that the goods must be from an identified bulk. Go through the definition under section 61. Bulk is defined as a collection of goods of the same kind which, first of all, is contained in a defined space. Secondly, the goods are fully interchangeable. In other words, the bits are all the same. Parties can identify bulk source either at the time of the contract or subsequent. In this question, the cashier says that the milk is stored in a tank in the warehouse. So the bulk is identified at the time the contract is made. And I think it's reasonable to assume that the litres of milk are all exactly the same. So this second condition also satisfied. The third condition for section 20 big A to operate is that the buyer must have paid. The buyer must have paid for some or all of the goods. We're told that Patsy has paid. Now, if Patsy paid in full for 100 litres, then Patsy owns 10% of the milk in the tank as owner in common with Dairywise and any other buyers. But we are told that the milk has gone off and is not drinkable. So we need to go on and discuss risk. Now, when section 20 big A applies, which applies in this situation, in this question, it is not clear whether risk passes to the buyer when the buyer acquires his undivided share or only later on when he acquires property by ascertainment and appropriation. Unfortunately, the Sale of Goods Act does not deal with this point. We know there are arguments for and against risk passing to the buyer. Explain that the two arguments for risk passing to the buyer when the buyer acquires undivided share depends on Ray's Parrot Domino and the case of Stearns against Vickers. The argument against this, in other words, risk remains for the seller, is based on 20 big B sub 3, which says nothing in 20 big B or 20 big A shall affect the rights of any buyer under the contract. We said we're not sure, but maybe the better view is against. In other words, Dairywise alone bears the risk, even if Patsy is 10% co-owner of an undivided share. That's because section 20 big A merely says that the buyer becomes an owner in common. This is not the same as full-blown property. So we think Patsy is entitled to her contractual rights of delivery of goods. Because risk has not passed to Patsy, Patsy is entitled to the refund of the price she paid for the milk. Don't stop there. Question: what happens to the contract? Because it is likely that all of the milk in the tank is unfit for consumption. This is common law frustration. Hilji Mulji against Cheong Yue Steamship. Now, if for any reason only some of the milk in the tank is undrinkable, then we're looking at Sainsbury against Street. This is the peculiar case, if you remember. 275 tons of barley was to be grown on a particular farm. There was crop failure and only 140 tons were produced. The seller sold the barley to a third party. The buyer sued for non-delivery. The court held that although the contract was frustrated as to part of the crop that failed, the seller was not entirely excused from performance. There was an implied term that the seller must offer the crop actually produced to the buyer, and the buyer had the option of taking delivery of a smaller quantity at a pro rata price. You should, of course, mention that this case was before the amendment to Section 30, sub 1. Now, of course, Section 30 has been amended so that the buyer cannot reject if the difference is small or it's trivial. Having said that, if Dairywise does have some milk in the tank which has not gone off, and they are offering it to Patsy, although Patsy does not have to accept a smaller quantity, explain to her that she is under a duty to mitigate. So if milk prices were going up, Patsy should accept the smaller quantity. Otherwise, the court might not allow her to claim for loss, which could be avoided. Needless to say, if Dairywise is unable to offer any at all or only offer a smaller amount, the balance of the contract will be frustrated and the remedies will fall under the 1943 Act. Now, don't stop there. I think there's one more point we should raise. See, we're told that the milk had gone off. Now, we are assuming this is not Dairywise's fault, because remember, Section 20 sub 3 says, if the person says that the person in possession of the goods has bailee duties to take reasonable care of the goods. It is unlikely that the milk going off is Patsy's fault, right? Because there was no delay in her taking delivery, which is the 20 sub 2 exception. That's because she agreed to buy the milk and she got the phone call the very next day. So I don't think 20 sub 2 applies. So the answer to this part of the question about the milk involved a big discussion of 20 big A and the for and against arguments about risk. In this question, it's pretty clear that Dairywise only found out the milk had deteriorated when they extracted 100 litres for Patsy. All the milk was still swilling around in the tank when they extracted the milk, so the goods never became ascertained. But you do need to read the question very carefully. Now, I think that's a good place to take a 10-minute break. All right, I'll see you in 10 minutes. Okay, welcome back. Now, oh, sorry, I'm sorry, I didn't realize there were questions on the chat thing. Let me have a quick look. It's very unfair that Patsy needs to bear the risk and loss of the eggs. She's probably taking advantage of it. Well, it's not a matter of fair or not fair. You and I, seller and buyer, you and I can agree anything we like. The law expressly allows us to agree anything we want. So if I'm the buyer, if I'm Patsy, I could agree with the seller. Listen, anything goes wrong with the eggs, it's your problem, because unless those eggs are in my hands, no risk. The law will support you. The only reason why we look at Section 18 rules is purely because the buyer and seller don't say anything. They don't agree anything in advance. Most buyers and sellers don't, of course. You go to a shop, you buy something, you don't say, oh, when is property? You don't say things like that. But if you want to agree something in advance, brilliant. The law will back you. But if you don't agree something, then the law will imply certain things into your contract. So it might sound unfair, but hey, it's your choice. If you don't expressly agree something, that's your right. Okay? Now, as far as that question is concerned, I want to twist the question a little bit. Let's have a look at this. All right. This is the same question, Patsy. Now, it's on the next page in your handouts anyway, page 21. Let's see what happens when part 3 changes. The only change here is that we are told that 100 litres of milk was extracted and set aside. It was labelled with Patsy's name. But an accident happens and the milk, which was set aside, was spoilt. How would you advise Patsy now as to where property and risk is? What I'm trying to illustrate to you is you have to read the question carefully, because if it was a little bit twisted, a little bit changed, your answer will be quite different. Well, your rough work then would be this for that part 3. If 100 litres have been set aside, then the milk has become ascertained. If that's the case, you need to discuss Section 18, Rule 5.1. Property passes to the buyer when 4 conditions are satisfied. Goods of contract description, in a deliverable state, are unconditionally appropriated with the seller or buyer's assent. If nothing else has happened apart from 100 litres being put aside, then although the milk has become ascertained, there is no unconditional appropriation, not even if the milk was labelled with Patsy's name. That's Carlos Federspiel against Charles Twigg. 75 bicycles were sold FOB. The buyer paid in full. The bicycles were packed in cases labelled with the buyer's name. Shipping instructions were issued, but the goods were never shipped. They were not even dispatched from the seller's warehouse. The seller went bust. The seller argued that he owned the bicycles, which were already packed in cases with his name on it. Court said property had not yet passed because the bicycles were merely set aside. The crates labelled with the buyer's name did not amount to unconditional appropriation of those bicycles. The property, therefore, remained with the seller. Now, if Patsy was not told to come collect the milk or even given a delivery note or anything, then property does not pass to Patsy. So risk does not pass to Patsy either. So the loss of 100 litres would be the seller's loss. But what it does mean is that because Dairywise set aside 100 litres out of their tank of 1,000 litres of milk, Dairywise only have 900 litres of milk left. Since Patsy has paid for the milk when she placed the order, it means she now owns 100 out of the 900 litres in the tank. And when does property and risk pass? Well, this is now back to section 20 big A. If 100 litres were set aside and only the 100 litres had deteriorated, but Patsy did not know anything was set aside, this involves a quick discussion of section 18, rule 5.1. Only a quick discussion, because even if the milk is ascertained, there is no unconditional appropriation. So property and risk on the 100 litres remains with the seller. But this does mean that there's less in the identified bulk. So if the buyer had paid, then the answer is about 20 big A. Now, of course, you will know exam technique. If we give you a 3 or 4 part question, then it is likely we want you to discuss different aspects of the transfer of property and risk rules. So when you do your rough work and you end up only discussing section 18, chances are you've gone wrong. Where is the discussion on section 20, big A? It's a very important exception. Now, that's a very full answer. I can't see what else we can add. You would get top marks for an answer like that. Now, property and risk questions come up in the exams all the time. Property and risk questions are really lovely. It's clear cut. There are only 2 types of goods in the whole world. But the problem is, if you get the type of goods wrong, there is nothing we can do to help you. We want to give you marks, but if you talk about specific goods when actually the goods are unascertained, then that's that. We can't give you a single mark. It is heartbreaking, I can tell you, when we can see that you are a top student because you've written a perfect answer to part A and a really, really good answer to part B. But then suddenly you get to part C and you get that completely wrong. You say they are specific goods when in fact they are unascertained goods. There are 2 completely different sets of rules. We cannot give you marks when you're talking about the wrong set of rules. There is nothing we can do to help you. But if you identify the type of goods correctly, then the answer flows. You can achieve very high marks answering property and risk questions. All right, let's move on. We said there are 4 major areas under the Sale of Goods Act we need to look at. The first is passing of property and risk. We've done that. We've finished that. The second big area is Nemo data. Let's start looking at that now. Now, the syllabus talks about transfer of title. The Sale of Goods Act uses 3 words: title, property, ownership, but only property is defined. Section 61 says property is the general property in goods, not merely special property. We discussed this. We said essentially general property is ownership. Ownership is a bundle of rights. We said property is the absolute legal interest in goods. So we know what property is. We know what ownership is. So what is title? Well, title is relative. It is the strength of your interest relative to someone else's. You see, I own my fur coat. I have the best possible title. I lend you my coat. You refuse to give it back. Well, my title is better than yours. The law will make you give it back. Leading case, Armory against Delamere. A chimney sweep found a jewel whilst he was working. He took it to a jeweller to get it valued. When he went to collect it, the jeweller refused to give it to him. The chimney sweep sued the jeweller. The jeweller argued, hey, the chimney sweep had no title to the jewel. The court held that the chimney sweep did not have absolute title. That's true. But he had better title than the jeweller. he had better title to everyone except the original owner. So title, you see, is relative. The true owner's title, of course, is absolute, but the chimney sweep has better title than the jeweler, who had no title at all. This case has been consistently followed, and it's often called the finder's cases. There are exceptions, of course. I mean, an occupier of land, for instance, is entitled to things attached to or under the land. So the occupier has better title than a finder. Just to illustrate that, one case is Corporation of London against Appleyard. A builder was repairing the foundations of a building. He found an old safe built into the wall. There was loads of money in there. The builder handed the notes to the police. No one claimed the money, probably because they'd been killed during World War II, because all the banknotes were dated about that time. Question for the court: who owned those banknotes? The builder argued he found the banknotes, he is entitled to them. The court held the building owner, he was entitled to the notes, because the safe was built into the wall of the building. So the safe formed part of the building. So the building owners were in possession of the safe, even though they were ignorant of it. In fact, there are lots and lots of interesting cases on this. As I say, they're called finder's cases, but two is enough for our purpose. So when we say a person has title to goods, we mean he has rights of ownership to goods. The strength of claim is relative. The true owner's title is absolute. Well, this part of the syllabus is about transfer of title. It's about a seller who is not the true owner of the goods, but he sells them to a third party. Now, note, by the way, that the Nemo DAT rules, which we're going to look at now, the Nemo DAT rules apply to B2C contracts. In other words, they apply to consumer contracts as well. Now, we will study this later in detail, but Section 12 of the Sale of Goods Act and Section 17 of the CRA says exactly the same thing. The seller must have the right to sell goods. Otherwise, the seller is in breach of an implied condition. Section 12, Sale of Goods Act, same as Section 17 of the CRA. The seller must have the right to sell. Now, the very leading case here is Roland against Duval. The buyer bought a car. He used it for 4 months. Then he found out that the car was a stolen car. The buyer sued the seller for breach of Section 12 title. The buyer claimed his full purchase price back. The seller argued, hang on a second, the buyer's had 4 months' use of the car, so he should only have to pay back the purchase price minus 4 months' use. Lord Atkin said the buyer was entitled to get all his money back on grounds of total failure of consideration. What the buyer wants when he buys goods, he wants title, he wants property, he wants ownership. Although the buyer got 4 months' possession, Atkin treated this as a total failure of consideration. Possession is a benefit, but it is only a collateral benefit. Now, this case has been criticized. We will talk more about this later. Well, this situation is fine between the seller and the buyer, but we are looking here at what happens when a rogue is involved. Not a thief, a rogue. The situation we're looking at here is where the owner sells goods to a rogue and the rogue wrongfully sells those goods to a third party. Sure, the third party can sue the rogue for breach of Section 12 or Section 17, depending on whether it's B2B or B2C. But the problem is the rogue invariably cannot be found, or he's bust, or he's insolvent, he's got no money anyway. So the question always is, who owns the goods? The original owner or this bona fide third party? Now, both of these people are innocent, but one of them has to lose out. The general rule is nemo dat quod non habet. You cannot give what you haven't got. So if the rogue has no title, the rogue cannot pass title to a third party. The nemo dat rule is set out in section 21 sub 1 of the Sale of Goods Act. Section 21 sub 1 says, where goods are sold by a person who is not their owner and who does not sell them with the authority or consent of the owner, the buyer acquires no better title than the seller had unless. Now, the idea behind the nemo dat rule is the preservation of the proprietary interest of the true owner. Nemo dat means you cannot give what you haven't got. So if you're not the owner, you cannot pass ownership. But problems arise where the owner voluntarily hands over his goods to a rogue, and the rogue sells them to an innocent buyer. The law needs to consider the interests of the innocent buyer. These are competing interests. Now, Lord Denning's quote is on page 22 of your handout, page 22. Let me just read Denning's quote out to you. Denning in Bishopsgate. In the development of our law, two principles have striven for mastery. The first is for the protection of property. No one can give a better title than he himself possesses. The second is for the protection of commercial transactions. The person who takes in good faith and for value without notice should get a good title. Now, what Denning is saying is there are two principles involved. Principle 1 is nemo dat. Principle 2 is the protection of third party. We need to have a practical balance. We need to have a pragmatic balance, a practical solution. You see, the situation always is one person is arguing, I am the owner. The rogue who sells to a third party, he does not have the right to sell, so I am still the owner. The other person, the third party, he has no idea who the owner is. But if the third party in good faith pays money for goods, his interest needs to be protected. The nemo dat rule is unfair to third parties. I mean, after all, the owner voluntarily gives possession of his goods to someone else. This someone else turns out to be a rogue. Surely, whenever you give someone possession of your goods, you always take the risk that something might happen to the goods. The owner is in a better position to assess the creditworthiness of the person he is dealing with anyway. And if that person turns out to be a rogue, why should the innocent third party suffer loss? So that's why lots of exceptions have developed to protect the third party. Lord Devlin in Ingram against Little said, where there are two innocent parties and one had to suffer the loss, there is no good basis for choosing between the two. He suggested we need to come up with a system so that the loss can be apportioned. It's fair. Devlin's suggestion was considered by the Law Reform Committee back in 1966, but they ultimately rejected the notion of apportionment. They said it was impractical. So how does the law deal with the problem? if apportionment is not workable. Because you cannot have two people owning the same goods. One of them is going to lose out. That's why Lord Denning said it's a struggle between these two competing principles. But note, not everyone agrees. Some say there's no struggle because the two principles are not equal. Lord Gough, in the House of Lords case of NEM against Jones, he said Nemo dat is the number one rule. Everything else is minor. We will look at NEM against Jones later. Because the loss cannot be apportioned, the existing rules place the loss on one or the other. Either the original owner loses out or the bona fide purchaser for value loses out. But the rules are not consistent, and frankly, sometimes they are difficult to justify. Let's look at these exceptions and see if they really are as minor as Lord Gough says. Note one thing straight away. The exceptions only apply if the buyer acts in good faith and without notice of the seller's lack of title. Section 61 defines good faith. A person acts in good faith if he acts honestly, whether or not negligently. What does acting honestly mean? Well, honesty is subjective. Just because I bought goods at a lower price does not mean I acted in bad faith. It might amount to evidence, but it is not absolute proof. And courts are very reluctant to infer bad faith just because a buyer bought at a lower price. Unless, of course, it was a really, really, really low price or there were suspicious circumstances. In all of these cases, except section 23, because of the wording of section 23, the burden of proof, of proving good faith, is on the buyer. This is reasonable because it is the buyer who wants the benefit of the exception. So it is the buyer who must prove he acted in good faith. We're saying that the Nemo dat exceptions only apply if the buyer acts in good faith and without notice. Notice in commercial law usually means actual notice, just like we saw just now, section 18, rule 2. If specific goods are not yet in a dealable state, property only passes to the buyer once that thing has been done and the buyer has notice of it. Here, the Nemo dat exceptions only help if the buyer had no notice of the seller's lack of title. This means no actual notice. But the courts sometimes apply an objective test. I mean, the buyer is not under any duty to investigate the seller's right to sell, nor to scrutinize documents with great care. But if the circumstances are so suspicious and the buyer deliberately turns a blind eye, that's what Lord Denning said. Denning said the court might infer that the buyer acted in bad faith. That's what Lord Denning said in Worcester Works against Couden Engineering. Denning's quote is in the handout. Read it in your own time. We will be looking at the facts of Worcester Works later on anyway. But the standard case on good faith is Heap against Motorist Advisory. The mercantile agent here was a rogue. He sold the owner's car without permission to a buyer who happened to be car dealers themselves. But the sale was a bit dodgy for 3 reasons. First of all, the car was worth £210, but it was sold to the buyer for £110. Secondly, the mercantile agent did not offer the registration document. Thirdly, the mercantile agent asked for an open check, not a crossed check. He said he didn't have a bank account. the mercantile agent, of course, had no title to pass. So the buyer claimed the factors exception, which we'll look at in a minute. The question was whether the buyer had noticed that something was wrong. Court said the buyer did have notice of the defect in title. So the buyer cannot claim the protection of Section 2 of the factors exception. Now, we need to look at exceptions to the Nemo Dat rule. Some of the exceptions, as I say, are not entirely logical. The Sale of Goods Act codifies some of the Nemo Dat exceptions. We will look at 8 exceptions. The first one is the estoppel exception. Section 21, sub 1 is the general rule. Only the owner or his authorized agent can pass good title. This is the Nemo Dat rule itself. But Section 21, sub 1 goes on to say, unless the owner by his conduct is precluded from denying the seller's authority to sell. So you see, the first Nemo Dat exception is contained in Section 21, sub 1 itself. 21, sub 1 is often known as the estoppel exception, but it's not really an exception at all. Well, it is and it isn't. I mean, it's arguable it's not an exception at all. It's just pure agency law. If a principal authorizes his agent to sell his goods, no problem. The principal is bound to the third party. If the agent has no authority or he exceeds his authority, the principal might still be bound to the third party on grounds of apparent authority if the principal represented the agent's authority by conduct. So the principal and 30 will be bound anyway. So Section 21, sub 1 is saying the same thing. In other words, if the owner, the principal, by conduct represents that someone else, in other words, the agent, has the authority to sell, then third party gets good title. So it's arguable that this is not an exception at all. It's just normal agency rules. Mind you, the counter argument, the other side, is that we could say it really is an exception to the Nemo Dat rule. It's not agency. Because, you see, even if the principal is bound, the principal and the third party are not really in a contractual relationship. I mean, if my agent wrongly sells my goods, the third party can't sue me for defective quality, for instance. The only effect of the Nemo Dat exception is that the owner is precluded, prevented, we're stopped from saying that the seller is not the owner. That's why it's arguable it's not really agency at all. Well, let's look at the cases. The first case is Eastern Distributors against Goldring. The owner of a Bedford van wanted to buy a Chrysler car from the dealer. The owner did not have sufficient money for the deposit. So the owner and the dealer agreed that the owner would complete 2 loan proposal forms, one for the purchase of the Chrysler car and the other one for the purchase of the Bedford van by the owner from the dealer. The finance company rejected the application for the Chrysler car, but they accepted the proposal for the Bedford van. The owner then sold that van to a third party. Question for the court was, who was the owner? Because if the owner is still the owner, then third party gets good title. The court said the finance company was the owner. Finance company was the owner. The original owner is stopped from denying that the dealer was the owner of the van, because the original owner in intentionally represented to the finance company that the van was not his, but it actually belongs to the dealer. Because the finance company was the owner, the general rule is Nemo dat. The original owner cannot give what he hasn't got. So the third party lost out. That's because the finance company was the owner. The rule is this. If by his conduct the true owner allows an innocent third party to pay the price to somebody else, the true owner is precluded. He's stopped from denying that this somebody else, the seller, had the right to sell. Now, estoppel, of course, can only be raised if the representation by the original owner was intentional. There must be a representation by the owner. So, example, if I lend you my car because you are my friend, you sell it to a third party. The third party can't say he's got title because somehow I represented that you're the owner. No, I gave you possession only. Possession in itself is not sufficient. There must be a clear representation from me that you had the right to sell. Let's look at the other cases. In mercantile credit against Hamblin, Mrs. Hamblin wanted a loan. She offered her car as security. She went to a reputable car dealer who said he would make inquiries and let her know. The dealer said, you know what, it would be quicker if she signed the loan application form in blank, and he would fill in the details once a finance company has agreed to lend her the money. In actual fact, it was a normal hire purchase form. In other words, Mrs. Hamblin, she was offering to take the car on hire purchase. The car dealer was clearly a rogue, because without reporting back to Mrs. Hamblin, the dealer completed Mrs. Hamblin's form, and he completed another form, which was the dealer selling the car to the finance company. And Mrs. Hamblin was taking the car on hire purchase from the finance company. The finance company accepted the forms, but who now owned the car? Mrs. Hamblin or the finance company? The Court of Appeal said Mrs. Hamblin was still the owner because there was no intentional nor negligent representation. Mrs. Hamblin owed a duty of care, sure, but she was not in breach of that duty. She acted reasonably. She approached a trusted car dealership which had a good reputation in the area. Obviously, just not this salesman. So you see from this case, leaving a signed form blank, that did not amount to negligent representation on the part of the owner, even though this action facilitated committal of fraud. It shows the extremes that courts are prepared to go in limiting the application of the estoppel exception. In Eastern Distributors, there was clear intentional representation. In Mrs. Hamblin's case, there was no intentional nor negligent representation. So, what might amount to negligent representation? See the case of Moorgate Mercantile against Twitchings. A finance company let a car on hire purchase to a customer. The customer wrongfully offered to sell the car to a motor car dealer. Now, the finance company and the dealer were members of HPI, Hire Purchase Information. HPI, they keep a register of cars subject to hire purchase agreements. But this finance company was careless. They did not register this company's HP agreement. So when the car dealer checked with HPI, HPI said, yeah, the car is not subject to hire purchase. So the car dealer bought the car. The finance company said, hey, that's our car. The motor car dealer said, finance company, you are stopped from denying that the customer had the right to sell. You did not register that agreement with HPI. The House of Lords said the finance company was still the owner. Although the finance company was careless not to register the hire purchase agreement, this did not amount to negligent representation that the customer had the right to sell. There was no legal duty for the finance company to register the hire purchase agreement. HPI was only a voluntary organization, so the representation did not amount to intentional nor negligent representation. Estoppel cannot be raised. Wilberforce said, English law takes a robust line. The owner of goods is not under a duty to safeguard it. Wilberforce's quote is in your handout. Read it in your own time. Nowadays, of course, in the UK, there are various organizations like Equifax. They offer a service to people thinking of buying cars to check if the car has been reported stolen or subject to HP agreements. For a very small fee, they will ensure getting the wrong information as well. So anyway, just because an owner is careless, it does not mean estoppel can be raised. In Central Newbury against Unity Finance, a finance company bought a car in an auction. The rogue comes along and the rogue says, oh, I'll take the car on hire purchase. The finance company let the rogue take possession of the car and the registration book. 3 days later, the rogue sold the car to a motor car dealer, signing the logbook as if he was the owner. The finance company wanted the car back. The motor car dealer argued the finance company should be estopped because they said the finance company, by their conduct, were negligent. They handed the car and the registration book to a rogue. They ought to have foreseen the possibility that the hirer might sell to someone else. The Court of Appeal said the finance company is still the owner. Estoppel exception cannot help. Just because the finance company was careless, it does not mean estoppel can be raised. Lord Denning actually felt that the loss should fall on the finance company for its carelessness in parting with the car in such circumstances. But the majority of the Court of Appeal followed Lord Wilberforce's robust line, allowing the original owner to assert ownership over the bona fide purchaser for value, over the innocent third party. The bona fide purchaser for value could pursue an action against the rogue, of course, for breach of the right to sell. But this is likely to be a complete waste of time because the rogue has usually disappeared. The courts obviously applied a very narrow interpretation of what would amount to a relevant representation in estoppel. Here, the loss fell on the innocent buyer rather than the owner who parted with the vehicle to the rogue. Where the owner gives possession of his goods to a third party, he does not represent that that person has authority to sell, nor is it negligent to do so, unless it can be shown he owed a duty of care to the ultimate buyer. The court actually gave a very good example. The court said this: if a householder left the window open and that's why the thief stole the goods, sure, the householder was careless, but it does not mean that the householder loses his right to assert ownership of the stolen items. There is no duty of care owed to ensure goods don't get lost or stolen. So the conclusion is that the estoppel exception is very limited. It does not really help the innocent third party. Furthermore, even if a representation was made, the representation must have induced the third party into the contract. Estoppel, in some ways, is like misrep. Misrep you studied in contract law. If the false statement did not induce you into the contract, you cannot claim misrep. Remember the case of JEB Fasteners against Bloom? Well, the buyer bought the entire company, not because he relied on the falsified accounts, but because he wanted the services of the two directors of the company. You see, those two directors wouldn't work for anyone else. So the only way the buyer could get them to work for him was to buy the entire company. The court said the buyer had no claim in misrep because the false statements did not induce the buyer into the contract. The buyer bought the company for a completely different reason, not because of the false statements. You see, this principle is the same in estoppel. If an intentional or negligent representation was made, but you did not know about the representation, or you did not rely on the representation, you cannot raise the estoppel exception to help you. The case is Farquharson Brothers against King. What happened here was a timber company owned timber which they kept at someone else's warehouse. The company told the warehouse people they would get instructions from the company clerk soon about where to send the goods. The company clerk was a rogue. He told the warehouse that the timber is to be held on account of a person called Brown. Brown was actually the rogue's made-up name. In the name of Brown, the rogue sold the timber to the third party. The question was, who owned the timber? The timber company or the third party? Well, the House of Lords said the timber belonged to the timber company. The representation made by the timber company was to the warehouse. That representation did not mislead the third party because the third party did not know about it. So the estoppel exception cannot apply. The third party needs to rely and suffer detriment in order for the estoppel exception to help. Okay, well, I think that is a very good place for us to end today's lecture. When we've got a day off tomorrow, so when we come back on Thursday, we'll carry on and we'll start with the second Nemo Dat exception. All right, so the question here is, why do all these cases involve car sales? Well, it just so happens a lot of car sales involve rogues who don't own the car but sell it on. They can apply to other things as well. It can apply to computers, it can sell to dogs, it can apply to anything. All right. So it just so happens that most of the cases involve cars, but it does apply to other types of goods as well. All right. So day off tomorrow. I'll see you on Thursday, and we will carry on with Nemo Dat exception. All right. Good night.